Darlene Morgan here of Morgan Law Group. Today we're going to talk just briefly about estate planning for unmarried couples. Now, that's fairly common these days for people to decide for whatever reason not to get married. But if that's the case, then there are some very unique planning considerations that we need to account for to ensure that if something unexpected happened to one of the partners, that your wishes would actually be followed, and that there wouldn't be what you want to happen would happen. So for example, the way the laws are set up, of course, it's easy for a surviving spouse to get benefits under different scenarios. But when there's not a marriage legally defining the relationship, the rules are not cut and dry at all. And oftentimes, if there hasn't been advanced planning, the partner does not end up they can end up in a very difficult place. So for example, when one spouse dies, the home that they live in typically goes to the other spouse. Easy. However, when there's an unmarried situation, this does not happen usually that way at all. Sometimes the house will go to the kids of one of the partners, and then the surviving partner is left out in the cold, or they may even get, they may not have somewhere to live. They may get kicked out by the kids who want to sell the house. All kinds of bad things could happen. So one method to ensure that one partner's assets will end up going to the other partner and not to other family members is by making sure that the legal title is held correctly. So for example, you can title your home as joint tenants with right of survivorship. There's pros and cons to this. I would not recommend that you just do it without really talking to an attorney about the implications of it. But for example, in the case of a home, if both partners are listed as joint tenants, then if one partner passes, the surviving partner automatically will get that home by operation of law, which means without a probate and really fairly easily. Now, there can be property tax implications, there can be gift tax implications. So that's why I recommend that you would have discuss it with an attorney before you just change the legal title and what it all means. But there's also cases where the client may wish to leave their home to a third party, maybe their kids, but they want to make sure that their partner would be able to live in the home, maybe for the rest of their life. So where that's the case, we call that either a life estate or we leave it in a trust so that the surviving partner can enjoy living there with clear instructions. There's a lot of things we have to think about, like who's going to pay when the surviving partner is living in the home, and then at the end of the day, when they pass, maybe the kids will get the home. In between there, though, who's going to pay for maintenance, property taxes? What if the surviving partner ends up moving out or gets a new boyfriend or girlfriend and wants them to live in the house? So all those things are pretty easy to work out and to think through so that it's very clear. But what I see a lot of times is people don't think through it at all, and they haven't put any instructions for what would happen, and then it can end up in a big fight between maybe the kids and the surviving partner, which is not what you wanted to happen at all. So in these situations, I would recommend that you would meet with a lawyer so that all those details can be fleshed out and thought through, and then clearly put into place through usually a trust. So if you're unmarried and you want to learn more about estate planning for unmarried couples, please contact us. We're here in Orange County, but we do work with families all over California to make sure that if something unexpected happened, their wishes would be followed.